Unathi Nkayi weighs in on Miss SA contestant Chidimma Adetshina's nationality controversy. South African singer, radio and television host Unathi Nkayi recently appeared on MacG's podcast and Chill, where she shared her thoughts on the controversy that was surrounding former Miss South Africa 2024 contestant Chidimma Adetshina. The 23-year-old Chidimma Adetshina caused quite the stir on social media after making her debut on television as a Miss SA 2024 contestant. Nkayi shared that Adetshina, who made it as far as the top 11 in the Miss SA beauty pageant, was raised in the country as a South African and was born and raised in South Africa. I guess for me, the interesting thing is that Miss AA is privately owned. It is not a government state, or it does not belong to any public entities. Do we really have a say? Do they care? Don't they care? She said. Nkayi further mentioned that she understands that people on social media were concerned about the cultural representation who Adetshina will represent in this case, since she does not have any South African cultural background. The 48-year-old former Idol South Africa judge said, "I get why people are up in arms, but I also get why people are saying she is ours because she is and we raised her." She further stated that South Africans must learn to heal and forgive people from other African countries. There is a lot of unforgiving characters about us, sometimes as South Africans, because we are so triggered and hurt. And I just think that we need to forgive and allow people to show remorse, she emphasized. South African questioned Adetshina's identity and went as far as creating petitions for Adetshina to be removed from the pageant. The matter quickly escalated as far as her and her family being investigated by Home Affairs, which found prima facie evidence that Adetshina's mother may have committed identity fraud 23 years ago. This revelation forced Adetshina to withdraw from the competition. She pulled out of the competition 2 days before the finale of Miss SA 2024, releasing a statement saying that the entire matter was affecting her and her family's safety. On the other hand, Home Affairs may have to pay illegal foreigner 1 million rand after unlawfully detaining her for a month. The Department of Home Affairs will likely have to pay damages to a tune of 1 million rand to an illegal immigrant after the Eastern Cape High Court ruled that she was unlawfully detained for a month. The woman, whose name is withheld, was arrested on November 18, 2022 while hiding in a room where she conducted business as a herbalist. She was taken to Mthatha Magistrates Court on November 21st, where she pleaded guilty of contravening the Immigration Act. During her court appearance, she paid a 1,000 rand fine and she was subsequently detained at the Mthatha Central Police Station pending her deportation. She was released on December 2022. Aggrieved by her arrest and detention, she sued Home Affairs for 1 million rand in damages regarding her arrest and incarceration. In her application, she argued that her arrest was unlawfully because she was arrested without a warrant and was not informed of the reasons for her arrest, nor was she informed of the reasons of her subsequent detention. Even though she pleaded guilty for being in the country illegally, she said she was refused the right to challenge the lawfulness of her arrest in person or through an attorney, and the immigration officers failed to bring her to court within 48 hours from her arrest. She further added that she was detained in deplorable conditions and she was not informed of the reasons for her detention. In court, it was her that the herbalist entered the country in 2002 while fleeing from the political unrest in her country of origin. She said she told officials who arrested her that she made an application for asylum in January 2020. However, no further details were obtained of the status of her application. In response, Home Affairs said its members were entitled to arrest the woman as she failed to identify herself as envisaged in the Section 41 of the Immigration Act as a foreigner who is lawfully in the country. It was further added that her detention was authorized by the court as she was duly informed of the decision to deport her, as well as the reasons for her continued detention. Looking at the evidence, Judge Lindy Werisi said in 2017 the Constitutional Court declared parts of the Immigration Act unconstitutional and suspended the order of invalidity for 24 months pending Parliament enacting corrective legislation to cure the defect. Pending the new act, the court said an illegal foreigner detained shall be brought before a court in person within 48 hours from the time of arrest, or not later than the first court day after the expiry of the 24 hours, if 48 hours expired outside ordinary court days. This meant that at the expiry of the 24-month period in June 2019, the constitutional invalidity took effect. The impound provisions could not be applied. However, when Parliament failed to meet the deadlines to enact corrective legislation, the Minister of Home Affairs in 2023 approached the Constitutional Court for the revival of the order it made in 2017. Parliament was given another 12 months to fix the law. Judge Risi said the court will rely on the 2017 decision made by the Constitutional Court regarding the arrest and detention of illegal foreigners. Therefore, the judge added that detention of an illegal foreigner cannot exceed 48 hours from the time of arrest. Additionally, any period of detention longer than 30 days will be subjected to judicial oversight, whereupon the court will exercise its discretion in determining whether the period of detention must be extended or not, she said. The judge said that even though the department was right for arresting that woman, she was uneasy with the legality of how the officials conducted her detention pending the deportation. This court had before it fundamentally contradictory evidence of the two witnesses of the defendant, which is Home Affairs, on the substantial issues regarding the lawfulness of the plaintiff's detention until she was released. I see no reason why judgment should not be entered in favor of the plaintiff, the woman, on the question of the lawfulness of her detention for the already mentioned period, said the judge. Regarding how much the woman should get, Judge Risi stayed the matter until further notice. On the other hand, boys armed with pangas invade Northwest Secondary School, intimidating learners. 4 boys have appeared before the Mabato Magistrates Court in Northwest, facing charges of trespassing and intimidating after they allegedly invaded a school armed with pangas. Last Tuesday, August 6th, a group of boys allegedly stormed into a secondary school at Lomanyeng, close to Mahikeng, armed with pangas and roamed around the school premises, intimidating school learners, according to Colonel Adele Midberg, provincial police spokesperson in Northwest. The intruders roamed around the school premises, intimidating school learners. The police were immediately informed and quickly rushed to the school. Seeing the police, the boys fled the scene, leaving behind these pangas, said Mayberg. Police investigations led to the arrest of 4 boys aged between 16 and 20 on the same day. During the court's appearance, Mayberg said 2 of the boys aged under 18 were dealt with accordance with the Child Justice Act and diverted to a juvenile detention facility for a period of 6 months. The other 2 accused, Tato 20 and Sepangtai, 20, were granted bail of 300 rand each. Their next court appearance will be in September 2024, said Mayberg. Meanwhile, Provincial Commissioner of Police in Northwest, Lieutenant General Selo Kwena, has praised police officers for the swift response which led to the arrest. Kwena condemned the incident, stating that schools are places of learning where children should be safe and protected. And that's it from Injibs Crime. Stay tuned to Wese Crime and Correctional Updates.